This episode of Advocates the Podcast is supported by Taylor's Law School, where you master the skills, tactics, and ethics that these top advocates will be talking about.
Listen to the voices of the advocates.
Welcome to Advocates the Podcast. Today we have with us Robert Lazar, one of the leading advocates of his generation. From representing Supreme Court judges that have caused the ire of the all-powerful executive to suing sitting sultans, Robert Lazar does it all in his cool, calm, and unflappable manner. Welcome, Robert.
Thank you.
I'll start by traditionally, of course, going through a bit of your background. I know you were the youngest child, the seventh of seven siblings.
Yes.
Your father was a printer, your mom was a housewife, and you grew up in brickfields. None of your siblings ended up in the law. So, first question, why did you end up in the law? Why law?
I would think it was by default, actually. Well, you know, when I was growing up, it was all maths and science. The emphasis in Malaysia at that time was on maths and science, at which I was hopeless. So I had really little choice after my Form 3 exams. When I got to Form 4, to be put into what is called the arts stream, where we did everything in English. You must remember that. I'm a product of an English medium secondary education. So the choice really, once I went into sixth form and started applying to go to university, was really between economics and the law. I actually I was very interested in economics. But I was told that even to do economics, you need a very strong maths background, which I didn't have. So I suppose I ended up doing law.
By default?
By default, almost.
Like most of us do. Well,
Yes.
well, I suppose you are an example to all those art students. You know, if you end up in the social science and the arts, doesn't mean you'll end up by Skid Row, yes? Look at Robert Lazar.
Definitely.
Okay. And then, of course, you went off to England to do law, to read law at LSE. And you came back to Malaysia. But before I touch upon your experience in Malaysia, may I ask, did you ever consider staying on in England? You know, of course, the world was much a different place than now, but did you consider that?
I think only for a fleeting moment.
Why only a fleeting moment?
Because, you know, if you were in the UK in 1978, 79, when you just gone through a power strike, there were all kinds of strikes. The IRA was still very much in the news for all the wrong reasons. And more importantly, Margaret Thatcher had just come into power in 1979. So really, I didn't think there was much attraction there. And also, it wouldn't have been an easy thing to do, because I think the immigration requirements in the 70s and even after that, I would think were quite difficult.
So you came back home to Malaysia. You got a position at Shen de Le Mans as a pupil.
Yes.
Can I ask, why Shen? How do you end up in Shen?
Again, by default.
Okay, right.
I was actually supposed to join Screen.
Right.
I had made arrangements with Screen. There used to be a very good partner who used to actually do some, well, I'm told by my mother, the family lawyer was Mr. Stanley Peddy in Screen. And she wanted me to join Screen. And I wrote to Mr. Peddy when I was in the UK. And he said, yes, when you come back, there will be a place for you. But by the time I came back and I went to Screen to see him, all the places for pupillage had been taken up.
I see.
And I was told that I would have had to wait till January or February the next year. And so I was, at a bit of a loss. So on my way home, I picked up a copy of the Malay Mail.
Okay.
It's a true story, okay?
Okay.
I opened to the classified.
Oh my goodness! All right.
Yes, and there were, the notices of substituted service.
Oh, okay.
There were three notices notices of substituted service taken out that day in the Malay Mail.
Right.
One was by Ranjit Thomas and Kula, the other was by Lovelace and Hastings, and the third was Sean Delamore. I immediately eliminated Ranjit Thomas and Kula because it didn't have a Matsali name.
Okay. Were
So I
they,
wrote
they were in Ipoh as well, isn't it? They were in Ipoh,
No,
based in
no,
Ipoh
no.
anyway.
They were
Oh, I
all
see.
in
Right.
KL. They were all
All
in
right.
KL.
Okay.
So I applied to Lovelace and Hastings and to Sean.
Okay.
And in those days, of course, everything you did by letter.
Oh, wow. Okay.
And well, I was interviewed and offered a place by both. I accepted Sean because if you've been to the old offices of Lovelace and Hastings in Jalan Hang Lekiu, you will know that their offices were actually in a shop house
Right.
where the sparrows would be flying in and out of the shop house and building their nests along the 5-foot way. It wasn't air conditioned.
Okay.
Sean had something that passed off for air conditioning.
Okay.
Right. So that's how I ended up. But I mean, really, the fact is, in Sean, it was a bigger place, and I had more friends there. In Lovelace and Hastings, I may have been the only pupil if I joined them.
So I suppose what we can learn from that is never write off notice of substituted service.
Oh yes.
Yes, it substituted your position as screen with Sean Delamore, I suppose.
I mean, when I qualified, you never had legal directories or journals telling you where to apply and all that. Everything was really by way of word of mouth and who you knew.
I see. So you went to Sean and Ronnie Koo was your master. Could you just tell us what was the experience there under Ronnie? Was he a hands-on master or did he delegate a lot?
Well, Ronnie was a gem of a man, let me tell you that. And he could fit into any setting. But his interests were almost everywhere. He was in the turf club. He was in a business. In those days, computers were just up and coming, and he had a business called Data Prep.
Oh, I see.
Which he was on the board of. So he spent a lot of time either at the club or at his business. He was also on Supreme Insurance, QBE Insurance. You remember
Yes.
QBE Insurance? Yeah, he was also on the board of QBE Insurance. And he was, a man about town. So the practice in Sean anyway was that you weren't really bound to do your master's work. You're really, as a pupil, you are at the beck of call of everyone in the firm, whether it's a partner or an assistant. So invariably, the most amount of work that I used to get would be from others in the litigation department.
So as a pupil in Sean those days, in 1979, I think younger listeners might be interested in this. From what you were telling me just now, there is no structured program, is it, for pupils? Not like
Absolutely.
they have now big firms?
Yeah, no, absolutely none. It was entirely up to the pupil what he wanted to do with his time. I can remember there was a pupil, one of my fellow pupils, who didn't even meet his master during his time, and every afternoon he would disappear.
I see.
He would go, and he'll tell us that he'd go wherever he went, and really they left you to your own devices.
Well, I suppose you're going to tell me that pupil mate of yours has now become a Supreme Court judge. But anyway, I think Gopal has got something to ask.
Yeah, sorry, just to follow up on that, and just to, so listeners understand that Malaysia has a fused profession, unlike several jurisdictions which have separate professions. When you joined Sean as a pupil, what made you gravitate towards the advocacy side of things as opposed to the other types of sort of commercial corporate drafting work they would have had in Sean at the time?
Okay, Sean at that time, their policy was pupils would really end up in the litigation side of the practice. Even I even remember that even when you're employed as an assistant, you have to join the litigation department. So you become a litigation assistant. You only get into corporate or conveyancing maybe after 2 or 3 years if there is a vacancy there. So everyone had to start in litigation. But of course, it started to change during the time I was there. There were people who were going to do IR work on their own, I mean, without going through litigation, IP, IR, and then later tax. But otherwise, everybody did litigation. So if you ask the most senior partners in Shen today, they would have all done litigation for starters.
So there you are, young lawyer in Shen, going on, doing well. In 4 years later, they offered you partnership, 1984. You accepted. Were there any moments during that time where you thought, you know what, I'm just going to go off and form my own firm and form my own partnership?
No, actually, I think at that time it was almost a given thing that your aim is to become a partner in the firm. And if after 5 years you do not get partnership, that seemed to be about the benchmark that you then decide it's time to go.
That's, in the 80s then, it's quite fast then to be made partners, nowadays.
Oh yes. Yeah. If you look at all those who were made partner before me, I think most of them did it within 5 years.
I see.
The mobility, yeah. That seemed to be the benchmark.
But by the way, before I go on a completely different tangent, but when you joined the profession in 1980, when you called to the bar,
yes,
how many members of the bar were there at that time, roughly?
I go by the listing in the directory, in the bar directory. I think I would have been about number 900
okay.
on the list.
Right.
10 years later, I was still around there.
yeah. But that's because lawyers really never die, isn't it?
Yeah.
They just go on and on, like ever-ready batteries.
Yeah. But it was a much smaller profession now.
Right. Okay. Then, of course, in 1988, 8 years after you end up in practice, we had the Judicial Crisis. And quite frankly, I think the Judicial Crisis, although it's 32 years in July this year, and the effect is still felt today. It still continues to, I suppose, inform lawyer-judge relationship in Malaysia. References constantly made to that. When you talk about judicial independence, everything revolves around 1988. You were involved in those two seminal cases, one of in the cases there. Could you just tell our listeners, what was the 88 Judicial Crisis about, and how did you get involved as counsel for one of the judges there?
Okay, the 88 Judicial Crisis really arose because of a series of events which were construed by the executive. And when I say executive, I really mean one man. And that is none other than Mahathir Mohamad, who felt that the judiciary were going to be a barrier or will impede his position. And he was very critical of the judiciary. And there were several things that happened along the way. You remember I think it was 87, or was it earlier, that you had Operation Lalang?
That's right.
Yeah, when you had Operation Lalang, and there were, I remember Karpal Singh's case. Karpal Singh was detained under Operation Lalang, and there was a habeas corpus application.
Battleson.
In Ipoh. No, in Ipoh.
Oh, okay, right.
This is to release Karpal. And Justice Pei Swee Chin, who was then the judge, I think it was Pei Swee Chin.
Yeah, Pei Swee Chin.
Or issued the order of habeas corpus. And in doing that, he said that the decision to detain Karpal Singh was an irrational decision. Now, we lawyers understand the word irrational in a different way from which Mahathir Mohamad, the medical doctor, understood it. Right? So he thought that irrational meant that he should be heading for Tanjung Rambutan. And so it was things like that that really upset him. And then, of course, there was Bertelson's case. And there were several other decisions which led up to, of course, the ultimate thing was the deregistration of UMNO. The deregistration of UMNO and the challenge by Tunku Razali's Team B really precipitated the crisis, because there was an appeal to the Supreme Court And I think Mahathir felt at that time that if the Supreme Court heard the appeal they would have held against him, and he was not prepared to take that risk. He was not prepared to take the risk, and so he did what he did with regard to tribunalizing the then Lord President Saleh Abbas. But in doing that, in doing all that he did, Mahathir knew that there was a faction in the judiciary who would come to his side
To do his bidding, so to speak.
to do his bidding. So, although we want to blame Mahathir and say that he was responsible for the events of 88, my own view is that he would not have been able to do it if not for that faction in the judiciary. So often I say that it is the crisis was also a self-induced crisis. The judiciary or those who came after that very much culpable as Mahathir. It's very convenient to say it was all Mahathir, but I think there's more to it.
But that faction, as you put it, I suppose could be said to be led by the then Chief Judge of Malaya, who's at that time, I think, was number 2
Hamid
in
Omar.
the judiciary, Tan Sri Hamid
Hamid
Omar
Omar.
at that time. That's right.
That's right.
Who was
Yes.
then appointed by Dr. Mahathir to head the tribunal trying
Yes.
Tun Saleh. Now, obviously, it looks pretty obvious, sounds and looks pretty obvious to us lawyers that the number 2 shouldn't be head of the tribunal trying the proprieties of the behavior of the number 1, because the accusation will be he will be next in line.
That's right.
And as a result of that, I think a group of judges, Supreme Court judges, granted an injunction, isn't it, to injunct the delivery of the decision of the first tribunal.
Yes.
And what happened to them?
Okay, they were then suspended. They heard an appeal because what had happened was there was a judicial review before the High Court. The judge in the judicial review did what was a very convenient thing. He just kept adjourning his decision. And so Saleh Abbas's team took the matter to the Supreme Court. They sat on a Saturday, and in those days, courts were sitting on Saturdays. They issued an interim order restraining the tribunal from proceeding. On, I think it was the Monday or the Tuesday, they themselves were suspended.
Yep. And by day, this includes Yusufi, Seah, Wan Azmi, Wan Hamzah,
and Wan Sulaiman.
Wan Sulaiman. And they were then subsequently tribunalized themselves. And this is how you got.
Yes.
And this is how, in fact, you got involved. As you were one of the counsel, you acted for, or rather assisted Tan Sri Yusufi, wasn't it?
No. I was asked to act for Datuk George Seah.
I see. Right.
I drafted R.R. Sethu.
He was your leader.
Yeah, was my leader.
Do you feel like great pressure for this? I mean, never has this been done before, isn't it?
Oh, yes. Actually, I think for a few days we were all in shock when all this took place. First when Saleh Abbas himself was suspended, and then as things unraveled to get 5 judges in the Supreme Court suspended just like that, it took us a while before we even realized what was going on.
Well, eventually, your client was unfortunately, I suppose, removed. George Seah was found guilty.
That's right.
And I think only Tan Sri Yusufi and Tan Sri Azmi Kamarudin was let off.
And Wan Hamzah.
Wan Hamzah, right. I said, and then George Seah got dismissed from his position, essentially. When you were doing this, just one final question on 88. Could I ask, did you and Mr. Sethu and all that felt really you had the chance, or you felt this was just going to be a rubber stamp?
We were very... there were times when we thought we had an opportunity because there were certain rulings along the way which were in our favor. And I think at the end of the day, we thought definitely in the case of Tan Sri Wan Sulaiman and George Seah that they were going to be found guilty. And I think George Seah himself, he wrote me a letter actually saying that when he realized the composition of the tribunal,
I
he
see.
had no doubt in his mind.
Right.
I still have that letter somewhere. Maybe I should publish that. I have that letter where he was in no doubt that the composition precluded that. I think as far as the three who were exonerated, although they were exonerated and they came back to the bench, they were never the same after that.
Naturally.
When they sat on the bench, they were never the same.
Okay, fast forward 20 years after that, you end up in another type of case involving the judiciary. This is the 2008 VK Lingam Royal Commission of Inquiry, in which you led a team of lawyers from the bar as counsel in this matter. Again, did you feel, of course, the case attracted a lot of public interest. I mean, the background was there was judicial corruption, there was attempts, successful attempts actually, to fix appointments of the judiciary. What was for you yourself personally, going through that whole process, was it just to you, as far as you're concerned, this confirms what I've always suspected was going on in the last 10 years?
Oh yes, I think there's absolutely no doubt that whatever was unraveled at the Royal Commission merely confirmed what most lawyers, I would have thought, and maybe more than just lawyers, thought was happening in the corridors of power.
And I suppose the events of 2008 wouldn't have happened without 88, isn't it?
Yes, I think what 88 was the start of the rot. And one of the things about 88 is you can see that those who served on the second tribunal, well, even the first tribunal, the second tribunal, all went on to become holders of office, high office in the judiciary. Edgar Joseph went straight to the federal court. Yusof Chin became Chief Justice. Lamin became President of the Court of Appeal. So it is quite obvious that in return for favorable decisions, where these appointments were being made.
So, but when you did the inquiry in 2008, therefore, from personally on your side, so do you felt that this is vindication of what my previous clients went through 20 years ago, and I'm just going to unravel this whole thing? Do you feel that pressure or the need to do that?
Not really. I think the personalities didn't really matter, and I think, speaking as far as George Seah was concerned, I don't think he would himself have looked at it that way.
I see.
It was not a question of vindication of his position.
Right.
It is more an institutional matter, because the rot was really bad. It was.
Well, to pivot completely out from the events at the judiciary, in your CV, I noticed in 2009, 1 year later, you did the Standard Chartered Bank case versus the then Yams di Pertuan of Negeri Sembilan.
Yes.
And I think that case was the first and only case so far to have been heard at the special court before a 5-man bench, and it was actually a trial. How was that experience? How does that differ from your normal trial? I mean, it's not every day you see a shooting sultan, isn't it?
No, but then fortunately for me, the Yam Tuan chose not to come and give evidence.
Yes.
So I didn't have to cross-examine him in the witness box. It was a straightforward banking claim. The kind of claim that, if not for a defense of sovereign immunity, the bank should have got summary judgment. Right? It is one of those cases.
I see.
But because of the identity of the borrower, you had no choice but to go to the special court. And of course, at this time, because of it also helped, I think, that this was a bench that had come out of the 08 thing. So I think the bench at that time, led by Hamid Mohamad, he was the Chief Justice, they were very keen to use this as a means of showing that to a large extent the judiciary has been rehabilitated.
I see. I
And
see.
what better evidence of rehabilitation than to enter a judgment against a sitting sovereign?
Okay, but can I ask you personally, when you got the brief from Standard Chartered Bank, did it cross your mind that said, look, I'm not taking this, I'm not suing a sultan?
Well, actually, I came into the case later.
Right.
There were earlier proceedings where I was not involved. I came in when the matter was fixed for trial in the special court. So the question of not taking on the brief never arose.
I see.
But yes, it was a tough thing because this is the kind of case you can't afford to lose. Not because of the amount or anything. It's just that it's one of those things which you will not see. I don't think you will see a similar action.
But did you get, so you got the impression that the judges was, I suppose, bending over backwards to be fair,
Yes.
right? Despite the defendant being a sitting monarch, yeah?
Yes. But it was a clear case.
Okay,
It was
yeah.
a very clear case. So, there could not have been much doubt as to yeah.
You've been at the bar now 40 years, Robert Lazar. You've seen many, many changes. Of course, one area of change is simply membership of the bar itself, isn't it? How is that? How is the membership of the bar today? When you're talking about women, talking about demographics, how does it differ when you first came back from England?
Oh, it's a tremendous change. I mean, firstly, the size of the bar. The size of the bar. I mean, I find it difficult to keep track of the numbers. And every time I'm asked, these things, I have to keep going to the bar directory to see what number of practitioners on the rolls there are. So I think really it's going to be very difficult given the size of the bar and what we're now going through in terms of the pandemic, going to have a very telling effect. We've been through crisis before. This is not the first time. I personally have, I think, been through at least three other financial crises: the 80s and 97, and then in 2008. But this time, I think it's going to be different, and the profession will definitely feel it far more than it did in the past.
Yeah, but could I ask you about, as I said, your views on the changing demographics at the bar and the thing? Obviously, now there are more women at the bar than before.
Oh yes, definitely. I think they're beginning to outnumber the men especially at entry level.
Yes, especially that. But that's the thing, isn't it, Robert? As counsel myself, I go to court. You very rarely see, apart from a few, women really, handling the big, challenging commercial briefs, right? Despite the number of women at the bar, do you have any particular insight there why this is so?
I can't. I cannot. I've asked myself the same question.
Right.
Why is it that if you look at the numbers and you take that the number of women who enter the bar, and then if you look at it 20 years after that,
yeah,
you will find that the attrition rate for women is far higher.
I see.
Than it is for men.
Maybe that's
why?
Maybe that's one of the reasons.
I don't know.
Yeah.
I think it's not just something that's confined to the profession. I think you'll find it across. It's an issue that affects the society as a whole, I think.
The other thing about, of course, the change that you see, before I bring Gopal in, final question for me is this: the increasing, I suppose, how I would say is that the increase in the paperwork as an advocate. I mean. During my early days in practice, and I'm sure you yourself, you practice twice as long as me now, almost twice as long. Submissions, for instance, was actually done just after trials. You don't have all these written submission things. You don't have this huge bundle of authorities. My question here is this: do you think just because we got more paper, does this lead to does it deliver justice actually?
Well, I think to answer your question, I think it is the nature of the kind of disputes that we are facing that the courts have to deal with, which has changed. I think when I started practice, for instance, a large part of trial work involved personal injury claims, running down claims. You don't get that in the High Court now.
Yes, that's right.
It's all gone down to the lower court. So, and you are getting far more complicated matters being heard in the High Court. You also have a huge explosion in the volume of litigation, tremendous explosion. And of course, with a more efficient and larger number of judges, the thing we must take into account is the waiting time for trials has reduced considerably. That's an improvement. That's a huge improvement over the years, that you can reasonably expect a trial to be had and finished within 18 months to 2 years. Whereas when I started practice, you'll be lucky if you even got into what they call the fixing list within the first 2 years. So I would rather look at that in terms of of course, there will always be individual cases where things have gone very wrong. That will always happen. I don't think it's a systemic issue, but I think overall the quality of justice has improved because I think we are a far more transparent country, and if there's anything that goes wrong, everybody will get to know about it before the day is over.
Okay. Now, you talk about quality of justice has improved generally. And I suppose here Gopal would like to join in because I think he would like to ask about the quality of judges, isn't it, Gopal?
Well, just before that, actually, if I could just deal with a couple of pretty prosaic matters. Just people may be interested in how you actually do your work. So let's begin with written work, and I think just dovetails nicely with the question that Razlan asked last. And obviously, when you started at the bar, at the end of trial, you'd make your oral submissions immediately. Not so much in writing for submissions, but it has been, I think, safe to say, for the last 20 years, there has been more emphasis on writing. So I have two questions to ask you on that. The first is, has your style changed over the last 20 years in the way you do your written submissions? That's my first question. And my second question on written work is, do you think doing that, having to do written submissions, makes you a better advocate?
When I started off, and I would say even for the first 15 years of my practice, we never had written submissions. I can still remember a particular trial that I did with the late K.S. Narayanan on the other side before Madam Siti Noma in the High Court, when I drew up a two-page summary of the point, and that was after a long trial, and I handed it to the judge, and I got a stare from Nanu, as we used to call him, and he thought that he looked at me and gave, if looks could kill, Razlan,
Yes.
if looks could kill, I would have been dead 1,000 times that day. That's how we did it. In those days, we
Wow.
never had written submissions until much later. And I've never really been keen on written submissions, even till today. I've always held the view that if they don't want to listen to you, putting in a written submission is not going to change anything because they won't want to read it anyway. So, and I think you just spend a whole lot of time doing your written submissions and you add on things which don't need to be there. So I try and actually keep my written submissions as short as I can.
Has that style evolved over the 20 years? Has it always been that sort of very
I think
minimalist approach?
I think I've always adopted that approach, that I keep it to the minimum. Even when I get submissions from my opponent which run into more than 10 pages, I tend to stop reading after a while, because the attitude I take is, why should I read when the judges are not going to read it?
Okay.
My next question, again, just sort of more a matter of practice and the way you approach things. Let's say you have an appeal in a month from now. What are your personal first steps that you take towards preparing for an appeal?
When I get an appeal, when I am briefed for an appeal, and especially if it is an appeal after trial appeal, I still think it's very important that the notes of evidence be gone through. Not because, I mean, at the end of the day, they may not be that important. But I think the reason why you need to go through the notes to make sure that you've read everything, both in the witness statement and cross-examination notes, is in case you are asked a question by a judge as to what happened or what didn't happen, and you'd be able to give an answer. I think there's nothing more embarrassing than to be asked a question and then for the answer to be, I don't know what happened. So what I would do is to prepare for an appeal, I would really identify the issues and see, and with those issues in mind, when I read the notes, I will try and demarcate where that issue appears in the notes of proceedings. And I would make a note of all those page numbers. At the end of the day, it may just be a colossal waste of time. But I think that is something that we have to do. So I would do that. I would not really spend too much of time as far as the law is concerned, because I think, in most cases, the law is well settled, unless, of course, you're dealing with an area that's developing. Otherwise, you would tend to concentrate. I think that's the part really that I need to emphasize, that I think you need to master the facts of the case far more than the law.
Okay, then following from that, let me ask you this as well, just in terms of presentation. What percentage of time in your preparation for an appeal, what percentage of time do you devote to thinking about how you are going to package or present your argument?
Well, that depends on the nature of the appeal. But I would do that well before the written submission is even prepared. What I would have is a kind of a skeletal, kind of bare bones, a bullet point kind of a write up to say these are the key areas. Then you start building up on that. So in terms of that, once I've done that, everything else would be able to fall into place.
Does this approach work for trial matters as well?
Oh yes, I think as far as trials are concerned, it's very important that you know that there are two things that I always insist on in terms of both a trial and appeals, is to have a chronology. You must have a chronology of events, even if it is just a one-page chronology. You must know what happened when, and I always have that chronology in front of me. And the second is what I call the theory of the case. What is it that you need to have? That's actually a very basic thing, but sometimes we tend to overlook the basic parts of the case. So that those are the two parts which I do. And then, of course, in terms of preparation of witness statements, the more difficult part really is preparing your own client or your witnesses for cross-examination.
Okay, Robert, moving now to judges, which is what Razlan was hoping I'd do earlier. But I'm going to do it slightly differently than he and I first discussed. Let me ask you this. I mean, you've been at the bar for 40 years. You have appeared before some formidable judges. You've had Yusofi Abdul Qadir, and you've had Sri Ram, you've had Mahadev Shankar. So you've appeared before some formidable judges. So let me ask you, of all of them, and I think it's fair that you pick someone who's retired, so that someone who's on the bench today doesn't know how you feel. But let me ask you, which one of these retired judges would you say gave you the most butterflies, and why?
The most butterflies, I would say, I think one judge who was very unpredictable was Justice Anwar Zainal Abidin. I don't know whether you know who he is.
Yes, yes.
Anwar retired as the Chief Judge of Malaya, but before that he was in Johor Bahru and then came up to KL. Unfortunately, during the 88 crisis, he was on the wrong side. But as a judge, appearing before him was difficult because he was a very clever man. He was a very clever man, very underrated as far as that part is concerned. Very underrated on that. But he would surprise you. He would really surprise you. So you really don't know where he's going to come from.
So with the piercing question, in other words.
Oh, yes.
Yeah, with the piercing question.
Yeah.
That's an interesting choice. And if I ask you the same question with regards to any opponent that you've had again, I'd suggest you do it someone who's retired at the bar as opposed to someone who's still at the bar.
Yeah.
So you don't give away your secrets. But who would you say gave you the butterflies? Like the person you didn't like appearing against because of their intellect or their skill as an advocate?
Okay. I think the person who definitely I in fact even used to have nightmares, of having to go to court the next day was Lim Kian Chai. Kian Chai would tear you to bits, and he didn't mince his words. He never minced his words, and he just couldn't be bothered about opposing counsel. He couldn't even be bothered about the judge. If he wanted to say what he wanted to say, he just went ahead and said it. I had a long running winding up matter where he was on the other side. Yeah, Folin and Brothers. And he was, like I said, I used to have nightmares.
He's just celebrated his 100th birthday.
Good for him.
Yeah.
Good for him.
Okay, so that's interesting.
In fact, we used to say that actually he was a bully. I remember Lo Siu Chang, once in open court, turned around and told him, "Don't bully me. I know I am junior, but you don't have to resort to that." But that was Kian Chai for you. In court, he would do you no favors. But the moment you step out of court, he bore you no ill will whatsoever. And for him, it was just another case, and just went on with it. The person who was the ultimate gentleman, there were two actually. One was, of course, Raja Aziz, real gentleman. He would never demean his opponent, very polite. And the other, who was also very good to have as an opponent and who had a very good record, was the late Koo Eng Chin. Eng Chin was a gentleman of an advocate as well. And the thing is, both with Koo and Eng Chin, the respect that they got from the judges was fantastic. You won't see that. You will not see that today. The way they say. And the thing is, they never took advantage. They never took advantage of the respect that was given to them. That is a big difference. Today, there are lots of lawyers who do get that kind of adulation from the bench.
Adulation is the right word.
Adulation, yes. There are lots who get adulation and then use it to their advantage.
Robert, now that I've asked you about opponents and judges, have you had any particular cases that you've done where nothing has gone right? The ultimate horror case which has been jinxed from beginning to end?
Well, I'm glad you asked me that, because this is something I need to get off my chest.
Okay.
Because I think the leading case, and I think almost every advocate quotes the case of Gan Yok Chin and Lee something. I forget the full title. I think Michelle, you will have that, right? And everyone quotes it in the context of appellate intervention, right? It gets quoted for that, and what the Court of Appeal described as the judicial evaluation of the evidence, right? That's the test. Did the judge evaluate the evidence properly? So, in order to understand that, you must then go on to see what actually happened at the trial. which I appeared in, I came in halfway through. It was going so bad for the guys in Malacca that they actually they had to draft me in almost halfway through the trial, and we ended up before a judge who had already made up his mind. In fact, he made it very clear. The moment I appeared, and he called us into chambers at the end of the day to have a chat. He says, "Oh, it's very nice that you have come on board. It's good. It's good that you have come on board, but I don't know whether you have come in too late." Okay, so that already you know what, and that's when I decided, if you're going to lose a case, you better lose it on every ground that you can, because then your chances of appeal. There's nothing worse than losing it on just one ground. Lose on every possible ground, because then your chances of an appeal are much stronger. And why is it a horror? Why was it a horror? It's because the judge had not only decided the case even halfway through the trial. It was also because, I mean, this is my perception, because of the parties that we were representing. The other side were urbane, sophisticated persons, one of whom was living in Australia, whereas my clients were your typical country bumpkin type. Okay, although they were immensely wealthy, or rather, the old man had left an estate that none of us can even imagine, the size of.
Yeah.
But yet they were very, and it comes out in the judgments. The persons we represented were all, workman type. And unfortunately, the judge seemed to hold that view and decide the case on the strength of who the party was, And I think also the most difficult part about the case was, you had a young solicitor in Malacca who did nothing more than to draw a will and to have it attested, right, and prepared. And her entire career, because if the trial judge was correct, she was party to a huge forgery, right? And to me, that was a very important part, because what did this lawyer really have to gain from doing all this? But more so, her entire career would have been thrown into the Straits of Malacca, I suppose, with that kind of a finding. And judges, I think, ought to appreciate the effect that their decision is going to have, not just on the parties, but on others who had nothing to gain from the case. But the way it was going, it was just so bad that, of course, we were not surprised at the end of the day when we lost it. But the fact that we lost so big eventually was what made us succeed in the appeal.
I suppose that's your salvation, isn't it?
Yes, but I think that was the horror. It was a horror.
Okay, well, that's all I have. I think that's been a really interesting session.
Right.
Robert, thank you so much for spending this, nearly 1 hour with us now.
Yep.
And Razlan, thank you so much for your hard work on this as well.
Thanks, Gopal. Thank you for listening. Keep an eye out for our next episode on our website and social media feeds.
Listen to the voices of the advocate.